Hello, and welcome to the New South Wales Community of Policy Professionals 2022 webinar series. My name is Louisa Mamooney, and as host of our webinar today, I acknowledge the traditional owners of the lands on which we are meeting. I'm on Gadigal land, and wherever you may be joining us from, I recognise this land as Aboriginal land and pay respect to elders past, present, and emerging, and welcome Aboriginal people who may be joining us today. In today's webinar, we're considering what happens when policy has the opposite effect of what it's intended to fix. In our webinar series, we have previously spoken about policy failures and its causes. And while its mirror policy success is much sought after, we need to acknowledge that failure can be a common outcome for policy as we strive to address difficult issues that are often caused by complex and interrelated paradigms which reinforce the status quo. Reducing the number of Aboriginal people in prison has been one of the priorities of Closing the Gap. It has challenged the shape, structure and decision-making of government. And with efforts failing to reduce the number of Aboriginal people in prison, what does this tell us about how policy approaches need to change and the role of policy in remediating past failures? Our speaker today is Brendan Thomas, Deputy Secretary at Department of Communities and Justice. Brendan is a proud Wiradjuri man, father of four and accomplished leader who has rejoined the Department of Communities and Justice after working with legal aid for the last 4.5 years, where he led work to ensure clients were at the heart of the important work that legal aid does. He significantly increased the number of Aboriginal clients and had 32 practicing Aboriginal solicitors. Brendan has worked for the Department of Justice for more than 20 years, leading major reforms in criminal, civil justice areas, introducing circle sentencing, reforming victims' compensation, establishing the Law Enforcement Conduct Commission, the design of crime research, the design of the Crime and Research Centre, Safer Pathway Scheme, Youth on Track, and he has also led major legislative and service reforms in the fields of domestic violence, services to victims of crime and Aboriginal communities. Brendan is now heading up vital work in a newly created division dedicated to improving Aboriginal outcomes in the criminal justice, child protection and housing systems. Brendan, thank you for joining us today, and I'll pass over to you for the presentation, and later we'll come back for questions and discussion. If you, our audience can keep your cameras off for now, but we'll welcome you back on during the Q&A session. So thanks very much. Brendan, over to you.
Thanks very much for that introduction, Louisa, and good morning, everybody. Thank you for taking the time to join us here this morning. I'm joining you from the beautiful country of the Barramatagal people here in Western Sydney in Parramatta. Just before I start, I think it's always important to try and share a bit about Aboriginal culture and our understanding of Aboriginal people. Just where I am in Sydney on Barramatagal country, Parramatta. In the language of Sydney, Burra means eel. Mata is a suffix that you apply to a word that means something that happens along a river. So Barramata means the river where people go to catch eels, and gull is the suffix in Sydney that you apply to a place meaning a person from that place. So Barramatagal person is the person from Parramatta. But it doesn't just mean that people came to Parramatta to look in the river and catch eels. It means that the dreaming and the songlines for the eel dreaming come through and have their heart in the country here in Western Sydney and Parramatta. So it's a really important place culturally and historically for Aboriginal people. And if you do live in Sydney, as many of you do, get to understand the place in Sydney that you live. Try and understand the name of the people that they come from, and you'll see your city in a different light. You know, often you hear an introduction or a welcome to country and people acknowledge the Gadigal people. Gadi is the grass tree, you know, the Xanthoria, the grass tree. Gadigal people are the people of the grass tree. That was the country that the city of Sydney is on now. I mean, you understand that, you might see your own city in a bit of a different light. But thanks again for that introduction, Louisa. What I'm going to talk through this morning, as Louisa said, is closing the gap in particular, and the challenge of closing the gap in the criminal justice system. And I might just share my screen, and hopefully You can see that shared screen?
Yes, we can. Yes, that's great.
So what I want to talk about today is really briefly at the first to talk about the Closing the Gap agreement, what it is and the priority reforms it sets for not just the New South Wales government, but for governments across Australia and what that might mean for all of you who are involved in policy setting. Then talk specifically about the target of reducing the prison population. And as Louisa said, the challenge of policy setting in trying to reduce the prison population when some of our policy settings might be having the effect of increasing that prison population. And talk about the role of policy in increasing the gap and closing it. So if I just go on quickly to talk about the Closing the Gap agreement and what it is, I'm sure all of you are familiar with the idea of this Closing the Gap agreement. This current agreement replaces the Closing the Gap process that Kevin Rudd had established when he was the Prime Minister. And importantly, is different in a number of significant ways. So the Closing the Gap agreement, as it was originally phrased under the Rudd government, was largely a Commonwealth government initiative. This current Closing the Gap agreement is quite different because it signs up all of the state and territories to the reform. It covers a broader area of activity than the previous Closing the Gap agreement did. And importantly, all governments have signed up to these 4 national priority reforms. In New South Wales, we've added a 5th one specifically, but I just want to talk about them just for a little bit. So the first one is the government has committed to establishing formal partnerships and shared decision-making for how it develops policy and manages services for Aboriginal people. Sorry, I've just lost control of the screen, I think.
Yes, we can see not your presentation. Oh, great. It's back on now.
Back up here? Sorry about
Yes,
that.
back on.
So formal partnerships and shared decision-making and how it designs and manages services for Aboriginal people. And the big challenge for us is, what does that actually mean? What does that mean on the scale of macro policy development and also service delivery? It's not just about consulting with Aboriginal people anymore. This is about sharing authority and decision-making with Aboriginal people and Aboriginal communities. We've got a couple of interesting examples in the justice system where courts, judicial officers are sharing their authority with Aboriginal communities. The Circle Court is a great example of that, where a magistrate sits with a group of elders and instead of the magistrate making a sentencing decision on their own, they share that decision with the elders and pass the decision that they come up with as a collective group. Great example of where decision-making is shared between, in that case, the judiciary and the Aboriginal community. But the Closing the Gap agreement commits government to looking at that all through the way it makes decisions. Secondly, there's a strong commitment to building the community-controlled sector. Some parts of government engage the community-controlled sector well, other parts don't. If I look at my own agency, DCJ, in the child protection section of the department, we engage the broader community-controlled sector quite extensively in the provision of services. In the criminal justice system, we don't really engage the community-controlled sector much at all. But this is a strong commitment to build services to Aboriginal people run and managed by Aboriginal people, and challenges us all in policy development and service design to make sure that we're thinking about that and thinking about how we build that community-controlled sector. The third is transforming government organisations. So really to put Aboriginal people and clients at the centre of how we design those organisations. That creates a lot of significant challenges when we think about applying that again at a macro level. In my organisation, DCJ, we're structured around our legal responsibilities and our service lines. We have a section that manages courts, section that manages prisons and the justice system, section that manages housing, section that manages child protection. From an Aboriginal community point of view, it's often the same families coming into contact with all those different parts of our department, sometimes at the same time. And at the moment, we're dealing with those Aboriginal communities as individual transactions rather than centrally as a family with a bunch of problems that we could potentially fix. This priority reform that the government signed up to under Closing the Gap commits us to thinking differently about how we put communities and people at the centre of what we do. Again, some significant challenges. And the fourth is the government has committed to share data and information at a regional level. That is to keep communities informed about what's happening in their community what services we're providing and how we're performing, and being quite open and transparent about those services. Again, another significant challenge. Again, if I look at my own department, DCJ, on the criminal justice side, lots of information is publicly available, and decisions in courts, for instance, are deliberately public. In other parts of the organisation, we don't share that much data at a local level with the public at all. Quite a challenging thing to do that. And fifth, in New South Wales, is a commitment to grow business opportunities for Aboriginal people. But what do those policy priorities mean for how we design policy and strategy differently? If we're really embracing this closing the gap target and this closing the gap agreement, we should be thinking differently about how we design policy from the very conception of it, and how we engage Aboriginal communities and organisations in making sure that we're sharing policy design and decision making with them. That poses a number of challenges. In some areas, that partnership is quite easy to identify, in others not so. It might mean some of our policy development is a lot longer than it might otherwise be. But it poses the question of how do we share authority in that kind of setting with Aboriginal communities and Aboriginal people in a way that's meaningful for them. And if policy and strategy is designed around people, how does that affect the structures of government? I just gave you an example from DCJ where we might have the same family involved in the court system, the juvenile justice system, the out-of-home care system, and they might be living in a DCJ managed house. How do we redesign our service system to deal with them as a family with needs, rather than a whole bunch of individual transactions or along our own lines of statutory responsibility? And does our data help or hinder us in doing that? So in DCJ, again, we've got mountains of really good data about our systems, almost no data about how that family experiences us as a family. A huge gap in our data when we start to try and think about how we put people at the centre of what we do. And what does that do for mainstream government service activity? So if we're reforming our services around Aboriginal people, what happens to the rest of the service system? So Aboriginal people accessing our court system are accessing the court system. They're not accessing an Aboriginal court system necessarily. So we need to think about, if we redesign our service system, how does that affect the rest of the service delivery system? Some really significant conceptual challenges for us when we're designing policy and services stemming from the government signing this closing the gap agreement. And we should all really be thinking about what they mean for us in the way we do our work. So just coming to that closing the gap agreement, I mentioned earlier, it's much more extensive than the previous closing the gap strategy that the Rudd government had. This one, the government has committed to making substantial differences in 17 specific areas, a much broader set of areas than the previous closing the gap target did. Everything from life expectancy to how many Aboriginal people speak languages to what proportion of the Australian landmass is under Aboriginal control. From my part of the government's point of view, a couple of really important additions. The last closing the gap target didn't touch the criminal justice system at all. This one does, and it does in quite a significant way. It has 4 targets that we're responsible for in DCJ: reducing the adult prison population, reducing the youth detention population, reducing kids in out-of-home care, and reducing all forms of violence against Aboriginal women and children by 50%. Quite substantial targets in really, really important areas of social policy and service delivery. But I want to focus this morning on one of those target areas, which is the commitment to reduce the rate at which Aboriginal people are imprisoned in the New South Wales prison system by 15% by the year 2031. Just importantly, to put that in a little bit of context, that target is the rate of Aboriginal imprisonment. So how many Aboriginal people for every 100,000 Aboriginal people are imprisoned, and reducing that rate by 15%. So often people look at this and they say, well, you're reducing the rate of overrepresentation by 15%. No, we're not. The focus is to reduce the rate of incarceration by 15%. So what's been happening with the Aboriginal prison population over the last little while? That graph on the screen looks at where the Aboriginal prison imprisonment rate has gone over the last 15 or so years. And you can see it moves around a fair bit, but it's generally going up. So from 2006 to 2021, the rate of Aboriginal imprisonment in New South Wales has increased by 41%. So a pretty substantial increase in the rate of imprisonment. So that's growing beyond, well beyond the pure growth in population. So an increasing rate and likelihood of arrest and imprisonment for Aboriginal people. So if you look at that kind of increasing prison rate and you look at what might be, you might think the natural drivers of an increasing imprisonment rate, you would think, well, you look at that, we've probably got an increasing rate of crime and an increasing rate of offending in the Aboriginal population. That will kind of be a natural assumption when you have a look at that kind of increasing prison rate, and the prison rate increasing by 41% over the last 15 years. So what's actually been happening to crime in New South Wales over the same time period? Well, if we have a look at the rate of violent crime in New South Wales, you can see, I mean, it jumps around a little bit like a heart monitor, but if you have a look at the trend, you can see that trend is just pretty significantly declining, starting to flatten out here towards the end of that time period, but it's a decline by 25% in violent crime in New South Wales. A really good thing, but quite a different trend to what we've been seeing in terms of the Aboriginal prison population. What's been happening in property crime? Well, you can see it's just a landslide downwards in terms of property crime in New South Wales. So between 2006 and 2021, we've seen a 62% reduction in property crime in New South Wales. Property crime are things like thefts, home burglaries, car theft, those types of crimes have dropped like a stone over the last decade in New South Wales, and indeed across the rest of the Western world. But your likelihood of having your car stolen and your home broken into in New South Wales at the moment is probably the lowest it's been since we've been recording crime. But I just showed you the growth in the Aboriginal prison population of 41% over that same time period. So what's been going on? Excuse my bad animation here. But there's the same graph of the Aboriginal prison population over a shorter time period between 2010 and 2021. And you can see it's relatively flat between 2010 and 2012. It starts to increase, pretty significant drop in 2013, 2014, and then kapow, pretty significant increase during 2014 and 2015, a steady rate of growth over that time period, and in 2020, a pretty stark decline. Again, if you were looking at external drivers of the prison population, you would expect to see the same kind of variations in crime and people's experience in crime. As I've just shown you in that previous graph, we haven't seen that. So what happened? Policy changes happened over that time period. So you can see the flat rate of imprisonment. In 2013, the government introduced a new bail law. That bail law followed a review by the New South Wales Law Reform Commission that made some pretty strong recommendations that the old 1978 Bail Act be changed and a different bail law based purely on an assessment of risk be brought in. And so in 2014, there was a new bail act brought in that was based purely on an assessment of risk. The previous bail act had been based on categories of crime, in which crime kind of gave a presumption in favour or against the person getting bail. The introduction of that bail act saw a pretty significant reduction in crime until the end of 2014. I wonder if people remember what happened at the end of 2014. You might not recall, but in December 2014, we had a siege in Martin Place conducted by a person who was on bail. You might remember Man Monis, who conducted that siege in Martin Place, was on bail at the time he did it. And you can see pretty quickly following that incident, a significant increase in the number of people going to prison. And what happened pretty shortly after that, you can see here, amendments were made to the Bail Act, which took the Act away from its focus on risk and put back in offence-based provisions where certain crimes have what we call a show cause provision, where you have to show cause why you should get bail, with the assumption being you won't get bail. And you can see the effect that had on the prison population, pretty stark increase. And that led to the continued increase of the prison population over time. In 2018, the government changed some policy again, changed the sentencing law, introduced a range of sentencing options that tried to encourage the use of community-based supervision for sentences rather than short prison terms. Gave community corrections officers or probation officers some additional authority to make decisions while they're managing offenders under supervision. And guess what? Started to reduce the prison population, but started to grow again shortly after that. And almost from the day of the COVID restrictions hitting, we saw a reduction in the prison population in New South Wales. And really interesting, not to do with policy changes, but to do with some pretty significant operational changes in the court. The court issued directions to have a greater presumption in favour of bail decisions, and suspended a range of court matters that we call defended hearings while the courts were closed. And when those hearings came back to be finalised and people had been on bail and not offended, those people were then less likely to be sentenced to prison. So I just show you a breakdown in sentenced prisoners, and you can see sentenced prisoners up by 36% over that same time period. And remand prisoners, those people who were in prison because of those changes to the Bail Act, up by 143% over that same period of time. So you can see this one thing, this one policy change in the criminal justice system has had a huge impact on the rate of Aboriginal imprisonment, irrespective of what those external drivers might be. So really interesting then, we see those general trends of an overall decline in crime rate, especially in violent and property crime, and particularly those crimes that are more likely to see you be sentenced to prison. So home burglary, for instance, has a 50% likelihood of receiving a prison term. We've seen that drop like a stone. Over that same time period, we don't have any evidence of any increase in the rate or the nature of Aboriginal offending. And in fact, there's some evidence to suggest that there's actually been a declining rate of Aboriginal offending over that same time period. But we've seen specific policy changes affect imprisonment much more than the crime rate has. As I showed you there, changes in the bail law have been really substantial in affecting the prison population. Sentencing law has also been substantial. And a policy shift in a greater focus on domestic violence. And I'll show you some data in a moment that will show the effect of that on the prison population. But taking domestic violence much more seriously and changing the law in the way we deal with domestic violence has also had a significant effect on the prison population. And you can also see from that graph the effect of events on the prison population. The siege in Martin Place had a significant shock effect on increasing the number of people into the criminal justice system. And the pandemic had the exact reverse effect, a reduction in the number of people going to prison. Both of those happening without necessarily policy changes, although there was policy changes following that Martin Place siege. Just want to talk a little bit about the drivers in the criminal justice system. I talked about that closing the gap target of reducing the Aboriginal prison rate by 15% over the next 10 years. What you can see on the screen, again, is that same kind of curve of the current Aboriginal prison population, the base rate calculated for the closing the gap target. And what we've got is where we're predicting the prison population to be if the current growth continues between now and 2031, and where we need to be able to meet that closing the gap target. So I mentioned earlier around that closing the gap target being a 15% reduction, being much bigger than it first appears. You can see what the gap is that we need to close on that screen if we do nothing and the current situation continues as it is. It's quite substantial. What does that mean in terms of actual people? Base rate, there was just on 3,400 Aboriginal people in prison. The forecast is if the rate continues to grow at the rate of growth over the last 5 years, by 2031 there'll be 5,700 Aboriginal people in prison. We can't let that grow beyond 3,600 to meet the closing the gap target. So that's a reduction effectively in the likely imprisonment of just on over 2,000, of some thousands of people over that period of time. So quite significant change is required in the criminal justice system if we're likely to meet that closing the gap target. Just a little bit of data to give you some kind of shifts again about how policy has been influencing the growth of Aboriginal imprisonment. What you've got here are two graphs around proven appearances of Aboriginal people in court between 2015 and 2019. And what you can see there is one of the things that's been also contributing to prison growth is just an increase in the number of people the police are bringing to court. So you can see between 2015 and 19, significant growth in the number of people being brought to court. The conviction rate over that period of time has stayed the same. The imprisonment rate's been relatively flat, that is the sentenced imprisonment rate. But the sheer number of people who have coming into the justice system has gone up. And what are they coming in for? If you have a look here, those top two areas of growth, breaching sentencing orders and intimidation and stalking offences, have both got to do with a greater focus of policy around domestic violence, a greater focus on enforcement of domestic violence orders, and a greater focus on being serious and harder on how we deal with offenders that might be involved in domestic violence offences. Both of these two things are results of greater levels of enforcement, not necessarily greater levels of offending in the community. So a greater focus on tightening up around offenders ends up with both of these types of charges going up. People being breached more often for the orders. Most of those breaches don't involve a fresh crime, but involve the breach of a condition of an order. And stalking and intimidation is a charge that can be laid without the victim necessarily having to prove that they actually feared for their own safety. So it's a charge that often gets laid accompanied with a breach offence. So you can see a greater focus on domestic violence in the justice system and a policy shift around domestic violence. While it's been good for focusing on DV, has had the consequence of shooting up the number of Aboriginal people coming into the justice system and therefore the number of people going into the prison population. Just a little bit more detail about bail for Aboriginal people. I showed you that that remand population was increasing. The likelihood of getting bail has significantly reduced. So you can see between 2015 and 19, the likelihood of being refused bail by police growing by 22%, the likelihood of being refused bail by court growing 11%. Both of those follow policy changes in the bail system and changes to the Bail Act. But again, just a little bit more detail. But what are the other things that are growing the Aboriginal prison population? The graph you can see on the screen at the moment is the rate of return to prison for Aboriginal people and other people by month of release. And you can see for Aboriginal people, on 6 months of release from prison, 46% of those people have returned to prison compared to 30% for everybody else. Still a pretty high rate for everybody, 30% of people being released to prison being returned back pretty quickly. Really high for Aboriginal people getting out of the prison system. So just a summary then of those major drivers of increasing Aboriginal imprisonment over the last little while. Total prison population up, really significant growth in the remand following those policy changes to the bail legislation. Violent offences up, and that's a lot to do with focusing on domestic violence. Breaches of sentencing orders, so breaches of parole orders and what we call intensive correction orders have added a quarter to that growth of the prison population, and that's got to do with a heavier focus on offenders and particularly a heavier focus on domestic violence offences following some really focused changes to domestic violence policy over the last 4 or 5 years. 16% increase in the number of people coming in. Again, a focus of violent offending of those people coming in, and that's a focus around domestic violence and the changes. Increasing rates of bail refusal, both in police and court. And increasingly, we're getting some evidence of systemic bias in decision-making in the justice system. So our friends at the Bureau of Crime Statistics and Research have done some really important studies around systemic decision-making in justice decisions and found some bias in sentencing decisions at court and some real bias in bail decisions by police. So being able to control for the factors that might make a person more or less likely to get bail, types of crime, criminal history, location, demographics of the offender, and controlling purely for Aboriginality, they found that Aboriginality makes you less likely to get police bail, but no effect on court bail. It's a really interesting example of where systemic discrimination in one part of a system can lead to compounding bias in other parts of that system. So if there is systemic bias in police decision-making around bail, and Boxer says there is through the data that they've made, but that bias isn't reversed when that bail decision comes to a court, but is just continued, then that bias is continued in the system. And really importantly, we know a refusal of bail once increases your likelihood of being refused bail anytime you come back before the criminal justice system. And we know people who have their bail refused are more likely, because of that bail refusal, to receive a prison term when their court case is finalised. So that one discriminatory decision right at the start of the system can have a whole heap of compounding effects as a person flows through that system, and indeed if that person comes back into that system again. And it's really important for us as policymakers to understand the flow and the impact of systemic bias in systems like the criminal justice system, but not only in the criminal justice system, and the role that that plays in the compounding disadvantage of Aboriginal people as Aboriginal people try and deal with big government systems like the criminal justice system. It's important for us to acknowledge it. It's really important for us to talk about it. And it's important for us when we're looking at designing systems and policy around those systems that we understand it, try and deal with it, and try and factor that in to our decision making. So if you have bail law, sentencing law, policies around how you assess risk for people in the justice system, and if they're all based on bail refusals making people more risky, prior prison terms making people more risky, and they all are, then they're having compounding effects on the disadvantage of Aboriginal people in those systems. It's really important to understand that, and it's really important through work like the work that Boxart done in the criminal justice system that we get increasing objective evidence around the effects of those kinds of things. So just really quickly then, what are we doing to try and reduce people's involvement in the criminal justice system? So I talked a little bit about what those drivers are, the key things that have been increasing Aboriginal involvement in the system. In DCJ, we're implementing a strategy around how we try and reduce that prison system, focusing on 5 key levers. I won't go into too much detail about this, happy to talk to anybody offline that might want to. But the first is to try and reverse that 16% growth in people at the front end of the system by providing greater opportunities to divert people. And by testing and thinking about how we police Aboriginal communities, where communities are involved in making decisions about how they get policed. Importantly, we've seen where that's happened in New South Wales, happened in Bourke, it's happened in a couple of other places for fixed periods of time. When police and Aboriginal communities have worked together and made decisions together, we've seen reductions in rates of arrest and reductions in rates of crime. Really important and powerful things. It's taking those key concepts of the closing the gap agreement and putting them into practice about how you share that decision making with communities around arrest. Around our bail system, we're not able to change the bail law. That's a matter for the government and the parliament. But we certainly can look at how we run our bail courts differently to make sure that we're maximising the opportunities for people to get bail. We're providing enough support for people when they are bailed to maintain that bail. And we're involving Aboriginal communities in making those bail decisions. Again, how do we share authority with Aboriginal communities in making bail decisions? In sentencing, we're trying to shift the focus from short-term prison sentences onto community-based orders. And again, working with communities about how we sentence Aboriginal offenders. And you might see in New South Wales, we're broadening the authority of magistrates to share and judges to share that decision making with Aboriginal communities. So we have circle sentencing courts in the magistrates' courts where communities and magistrates are sitting and making decisions together. In the children's court, we have the Koori Court, which does the same thing. And in the district court, about a month and a half ago, we started the Wallama Court, where that district court judges are sitting with Aboriginal elders and making decisions together. We're looking at how we can shift and reduce those breaches of court orders. And importantly, how do we run the prison system so that people are better prepared when they get out and provide better support when they do to get out to try and reduce that return into prison. But really importantly, I talked about those policy changes that are shifting more people into the system. And if you can make some big changes in those policy changes, like bail, around domestic violence, you can actually reduce the number of people flowing into prison. But if you don't, what's the level of effort that you need to put into programmatic things to shift the dial? What I've got on the screen is just some examples about the level of effort that's needed to simply keep 50 Aboriginal adults out of prison each year. Calculations done by our friends at the Bureau of Crime Statistics and Research. And I'll just run through a couple just to give you an indication of the level of effort. So that is not just to keep 50 people out of prison, but to keep 50 prison beds vacant for an entire year that would otherwise be occupied by Aboriginal people. To do that, we'd have to reduce 115 break and enter offences, 430 domestic violence offences, 210 non-DV offences, or 380 post-custody offence incidents. So you can see, to keep 50 beds vacant, the level of effort that needs to happen to keep those beds vacant is much greater than that. I showed you those figures earlier about having to reduce the prison population by some thousands of people. So you start to times this by thousands, you can see the level of programmatic effort that's required to reduce the prison population to meet the closing the gap target. A couple of these ones are really interesting. To focus on bail refusals, we have to significantly reduce bail refusals to keep 50 prison beds vacant a year. But I'll focus you on this one here, which is really important because it shows the effect of some small changes on such a big, busy system. If every Aboriginal person that was sentenced to prison over a 12-month period got 4 days less on their sentence, that would reduce the prison population permanently by 50 Aboriginal adults a year. What that also does is it shows you the reverse. If everybody who was sentenced to prison got an extra 4 days in their sentence a year, it would cumulatively increase the prison population by 50 Aboriginal people a year. And you can see the effect of policy changes there. Every time we get harder with the average sentence for a particular type of crime, or focus harder on particular type of offenders, it can have a significant compounding effect on adding to the Aboriginal prison population. But this is just to give you an indication of, if you don't make those big policy shifts in the system, what's the level of activity you need to do programmatically to have the same effect? It's much, much bigger and potentially much, much more expensive. So what's the kind of the major challenges and lessons you learn from that? There's only one justice system. So if you have policy that focuses on making it harder for people to get bail or going tough on offenders, guess what? It fills the jails full of Aboriginal people. That's the consequence of doing that. It's really difficult to run a justice system where you're being tough on crime on one end and trying to reduce Aboriginal overrepresentation on the other. You end up with the situation I've just described, with policy settings doing one thing and the need for a whole bunch of operational things to try and counteract those policy settings. And without changing policy settings, the activity needs to be significant, but we also need to plan for future system shocks. So I showed you the impact that those two kind of external factors had on the system, kind of a siege in Martin Place and the COVID pandemic. We need to properly plan for the effect that that has on the justice system. But I just wanted to end by telling you that there is some good news in this whole thing, and that's in the children's court. It's really dichotomous that we have one of the largest prison populations that we've ever had, while at the same time the lowest level of Aboriginal people in juvenile detention. I don't know what the figure was this week, but 2 weeks ago there were 14 Aboriginal juveniles serving a sentence of detention in New South Wales. 14. We have more than that on remand, but the number of juveniles sentenced is really low. The figures on the screen at the moment show where the closing the gap target needs to be for juvenile detention. Yeah, 15.7. Where we actually are, 13.3. We've actually met that target. It's pretty odd that the government signed up to a target that it's already met, and we should be doing everything we can to reduce the number of Aboriginal children in detention as we can. But you can see that significant decline in the number of Aboriginal juveniles sentenced to detention. And I'll just run a couple of graphs which hopefully will explain what's happened there. Forget the small numbers of lines here, just look at the trend. This is Aboriginal young males in detention, Aboriginal young females in detention over 4 years to 2021, and you can just see really dropping rates of Aboriginal juveniles in detention. This is the rate of reoffending. So how many kids, Aboriginal kids that are found guilty by court, that are exiting custody, that are returning to custody, are actually reoffending. And you can see those rates are declining a little bit, which is good, but not to the extent that those detention rates have declined. So is it a change in police practice that's causing a reduction of Aboriginal kids going to detention, into detention? You can see the number of police proceedings to court over that time has largely stayed flat, kind of lifted a little bit. So are police diverting more people from court, young people from court? You can see from those figures, they're actually not. Police rates of diversion are pretty flat. Are police giving more young people bail, and is that causing the reduction of young people in detention? And you can see from that graph, no, they're not. It's actually increased a little bit over time. But when we have a look at what the Children's Court has done, we're seeing where the key to this actually is. Number of people found guilty in the court has been slightly declining, but the number of people being sentenced to custody is down quite significantly. So even though the flow of kids into the court is staying the same, what the court is choosing to do with those young people has changed quite significantly. And it's changed because of magistrates' activity, and it's changed in one particular area because of the introduction of a thing called the Koori Youth Court, which I talked about earlier, where the court is sharing authority with local Aboriginal people and focusing much more on how it solves the problems that young people are presenting with at the court, rather than just adjudicating over legal cases. So instead of a sentencing hearing that might take an hour or half an hour, the court sits with community members, the young person and their family. They talk about the problems that young person experiences. They defer the sentence in that court while that young person can go off and do some things to remediate the challenges that they're having. And then they pass the sentence once a time period has passed, in conjunction with the elders that sit on that court. And that is resulting in a significant reduction in the number of young Aboriginal people being sentenced to detention. So a recent evaluation of that court found 40% less likely to go to detention for an Aboriginal young person dealt with by the Koori Youth Court compared to a young person with the same crime and criminal history being dealt with by a regular court. And similarly, the remand population has declined. The Children's Court, irrespective of the changes to the Bail Act, has chosen to give more young people bail, and it's chosen to continue that bail more often when those young people breach that bail. So changes in practice there from the Children's Court having significant effects on the way the youth justice system actually operates. So one of the things we have learned through all of this, that empowering the community really does work. That first premise of the closing the gap target, of how you share authority in making decision making, at least in the criminal justice system where it's happened properly, we've seen some substantial and measurable changes. I mentioned the Koori Youth Court having a 40% reduction on the likelihood of imprisonment. Circle sentencing courts, where magistrates in the adult jurisdiction sit in a circle with elders, talk to the offender, talk about what needs to be done to right the wrong of the offence and what might need to be done to turn the trajectory of the offender around, is having a significant reduction. In the adult jurisdiction, a 10% reduction in reoffending is actually really significant. There's a significant reduction in the likelihood of those people being sentenced to prison. And when they do commit another offence, what we're finding is they're taking longer to commit it than Aboriginal offenders who are going through the local court. A really great example of how sharing authority with local Aboriginal communities is making a significant difference in the operation of the criminal justice system. And really interesting, both of those things cost almost nothing. The cost of those courts is in time and effort, not necessarily in investment. It's just thinking differently about how you solve problems and really being prepared to share authority with local Aboriginal communities in making decisions in a real and meaningful way. The final one there is a police operation that operated in Bourke for a little while called Operation Solidarity, which again saw police commanders sharing authority with local Aboriginal community members, meeting with Aboriginal community members every morning of every day to talk about crimes that had happened overnight and how they could work together to resolve those crimes the next day. A really strong focus of working hand in glove in policing and Aboriginal communities saw a significant reduction in arrests in Bourke during that period of time, and a reduction in the number of people coming to court and the rates of recorded crime. So we know there are some things that can work. And just finally, just the final points I'd like to leave you with following that presentation. One is this closing a gap agreement. You should take the time to think about it and understand it, but it should really significantly shift the way government designs and manages policy. It should cause you to think about how you develop policy and strategy quite differently. It should cause you to try and put Aboriginal communities at the centre of that policy and really focus about how you're remediating the challenges that communities face and how you're contributing to actually closing that gap. Benefits to communities aren't just about policy shifts, but they're often about trying to fix broken and misaligned systems and trying to mitigate the unintended consequences of other policy decisions. But for changes to be made within government systems, that we need to cater for the other external influences that can often shift and change policy and have perverse consequences. That's it. I'll leave you there, Louise.
Thanks, Brendan. We've actually got heaps of questions already in the chat, but I'm going to coordinate them at least to tell people which order they should come on and ask their question. So the first question that I've picked, and it's feel free to restate your question more clearly if you're in our audience. Some of your questions are some of your comments are unclear to me whether it's a comment or a question. So if you want to restate it, that would be great. But I'll ask Sharon Valks to come on first and ask her question. If you can introduce yourself, the agency you're from, and then go ahead. Thanks, Sharon. Hopefully you're still with us.
I'm still here. I just have to find my question, and I'm just going to double check if it wasn't really more of a comment. Forgive me for bringing that one up. Where am I? Early in the piece. Just wondering if you could help me. I got so involved in everyone else's questions.
Yes.
Yeah.
Your
Thank
question is, how are we going to address systemic discrimination, stigma, and compounding bias? We've been talking about it for a long time, and I wondered, Sharon was wondering if Brendan, you have any suggestions about how to address that?
And thank you. I'm at the Office of Responsible Gambling, and yes, this is a particular area of interest of mine. So I'll leave it there. There's a comment and a question, really.
Yeah, well, firstly, we need to openly talk about it. We really need to talk about systemic bias and how it works in a system. I mean, you saw in the criminal justice system that bias in one decision at the front end just has a compounding effect as a person flows through. Even if people in the other parts of that system are blind to that bias, it still has a compounding effect. But you can't be consciously blind to that. So if you know that bias is happening at one end, what are you doing to mitigate it in your own decision making is really important. I think we need to objectively understand it. And that work Boxer has done around bail decisions is really important because it tries to objectively substantiate what that bias is, what the extent it is, what effect it has on those kinds of decisions, and so that we can actually try and understand how to fix it. And it embeds itself into other kinds of decision making. So I talked about, if we have sentencing law that looks at, or sentencing practice that looks at a previous term of imprisonment, makes you more likely to get a future term of imprisonment, because it does. That just bakes in any systemic bias that might be already in those decision making systems. And we need to think about, how do we unpack that and undo that level of bias? That's not an easy thing to do, because that requires policy change, law reform, thinking differently about how you assess risk. There's a lot of complicated things to unpick there, but the more we talk about it, the more we try to objectively understand it and measure it, the more then we can try and tackle it and deal with it properly in all of our systems.
Thank you for that.
Amanda, would you like to come on and ask your question about identification of Aboriginal people?
Yeah, probably. I probably just had a comment as well with respect to the Aboriginal inmate population. I guess it'd be good to understand the incidence of mental illness, complex and intergenerational trauma, and how exactly correctional centres contribute to rehabilitation. And my second question was around sort of from January 2022, police now ask victims of crime or persons of interest or people in custody if they are Aboriginal. And I guess from my perspective as an Aboriginal person, I would never tell a police officer that I was an Aboriginal person, knowing full well the bias that exists, both from the statistics that you're presenting, but also from familial experiences.
Yeah, just to answer that first question, the second question first, the police are asking more questions about Aboriginality than they have in the past. They've asked it for many years for people that are arrested, but there's a whole bunch of people that are dealt with in the criminal justice system that aren't arrested, for which we haven't had that information at all before. there's lots of gaps in our criminal justice data around Aboriginality, but there's been a lot of work over the last 20 years to try and improve that collection and make it as good as it possibly can be, largely led by the Bureau of Crime Statistics and Research. So the data's got holes in it, but it's as good as it can be, and I'm pretty confident the trends that I've just shown you are actual trends of people's involvement in the justice system. And to your earlier question about the role of trauma and mental health in the justice system, it's really complicated. Lots of people in the prison system have mental health concerns. Almost all of them have experienced trauma in one form or another. A third of Aboriginal men in the criminal justice system or in the out-of-home care system as kids, for example. I think close to 40% have an intellectual disability. The prison system does try and deal with that sometimes, but the way the system operates is people are in and out of that system often for relatively short periods of time. You know, the most common prison term for an Aboriginal person in New South Wales is still 7 or 8 months, where it's not long enough for any person to get any kind of treatment. And we really need to think about how we provide that treatment much better in the community. And part of our focus is to get people sentenced to community-based orders where they can receive that kind of treatment in a much better way than they possibly ever could in a prison system. But it is a significant challenge for all of us.
Next, I think we have Sophia. Sophia, would you like to come up?
Hi, thanks Brendan for your presentation, really great. I guess my question is about understanding the conversations that are happening, you know, at a high level, you know, the things that we're not particularly privy to. And I'm just curious to understanding how the New South Wales Police Force is included in the Closing the Gap targets, particularly in light of police quotas and targets that they have to meet, and also systemic bias.
Yeah, there's a challenge for how we measure the whole criminal justice system to properly address these closing the gap targets. And if your focus is purely around crime reduction, as it is, I mean, the police don't operate under arrest quotas and those kinds of things, and that is a common perception that they do, but they do have targets around crime reduction, and that does drive, you know, increased rates of arrest. And we need to shift that to be around measuring prevention and measuring community cohesion. You can do that, and there's been some strong international movements around community policing and engaging community policing, where lots of international police forces have thought really hard about how do you measure success in reducing crime that's not necessarily just based around arresting and incarcerating offenders. And I mentioned there has been some good examples of that happening in New South Wales, but they have tended to rely very heavily on the activities of a local area commander, and therefore aren't sustained once that local area commander moves on. And we need to think with the police, and part of my job is to work with the police to encourage them to think differently about how they police Aboriginal communities in a way that shares authority with those communities.
That is a good entry to our next question, which was asking about local pilots, particularly the one in Burke. Julia, would you like to ask a question? Oh, you'll have to turn your mute. I can't hear you.
Sorry, novice move. Thank you for your presentation, Brendan. My question was just about, and I know that some other people have asked about it as well in the chat, the status of Operation Solidarity in Burke, whether it remains ongoing and whether there's any move to use it as a pilot for other police programs in New South Wales that you know of. I suppose a sub-related question that people are also asking about in the chat, which I'll just, say relates to the same issue, is it a good example perhaps of how you might go about preventing domestic violence without, is that a good example of increased focus on domestic violence that doesn't necessarily incarcerate Aboriginal people but does protect victims, perhaps?
Yeah, I mean, Operation Solidarity was run by a particular local area commander who moved on, and it's kind of dropped off a little bit since he did. I understand the police are trying to revive it there in Burke as we speak. It is a good example about how you can work in partnership to reduce crime and domestic violence. Domestic violence in Aboriginal communities is a really good opportunity, a really good example of a lot of perverse policy design causing some unintended consequences. Unfortunately, most domestic violence services, the vast bulk of domestic violence services, are accessed by victims following a referral from the police. And police, as you know, are mandatory reporters under our child protection system. So I can't tell you how many Aboriginal women I've heard say, I'm not going to call the police to get help with violence because I'll call facts and facts will take my children. And so you have a law enforcement and a child protection system designed in such a way that's creating a disincentive for people to actually seek assistance. And our service system is designed, to be frank, in my view, on a really Western way of understanding family structures, where there's kind of an unwritten assumption that in a domestic violence situation, the family will split. And in a lot of Aboriginal communities, the women don't want to leave the house, they just want the violence to stop. And we don't have a service system that helps with that circumstance. It's a good example of where we really need to redesign a service system around the problem that it's focusing on and the people that it's dealing with. Because the way it's structured at the moment is a whole bunch of real disincentives for Aboriginal families to use it properly.
Shay, you were going to ask a question also about domestic violence, but I wonder if that has already covered that topic. You'll feel free to come on and ask a question.
All good. I think that pretty much did cover it. I was really just asking around what sorts of things could we do early on to try and prevent the risks from that domestic violence in the first place. But I think that's covered in the previous question. So obviously, you know, I think there's still a lot of work that we need to do there. So I'll just take this moment to say thank you, Brendan. This has been a really amazing presentation, really informative, very thought-provoking. And I think a couple of people have said in the comments, like, a really good use of data. So thank you for coming and talking with us today.
Oh, that's nice. Stephanie, I think we might move to your question next. Stephanie, would you like to come on and ask your question?
Yes, hello. Just echoing what Shay said. Thank you so much, Brendan, for such a thought-provoking, detailed and well-delivered presentation covering some really interesting policy areas for us all to think about. One of the pilots that I worked on a couple of years ago was the family investment model in Dubbo and Dempsey, piloting that localised multi-agency case management. I wondered if anything has progressed since the family investment model, adopting a similar approach. I know you mentioned that may be something that could be useful, acknowledging that Aboriginal families have multiple touch points across DCJ and New South Wales government.
Yeah, I mean, the family investment model was a good attempt at trying to bring different parts of the government together to focus themselves around the challenges that families have. And certainly the challenge for us in DCJ, and I think the purpose for the agency coming together in the way that it's come together, is to try and rethink the way we design our services to try and meet the needs of those families. And we've done some work looking at the progress of Aboriginal families through the different parts of DCJ service system. And you can see lots of transactional interactions with people and the problems kind of compounding over periods of time. And if we just thought differently earlier on and invested some greater effort up front, we might have kind of bent the curve on that trajectory. And I think that's really where we in DCJ really need to focus ourselves. You know, family violence in Aboriginal communities is the place where you see that coming together. You know, our Closing the Gap targets about reducing the prison population and reducing kids in out-of-home care. You know, a fair chunk of that has family violence at its heart. And unless we can tackle those family violence problems, the structural problems that we've got in the way we deal with it, as well as engaging with Aboriginal communities to empower them to prevent it better, then we're not going to make a huge dent on those Closing the Gap targets.
Thank you.
Thank you. And with that, I think we'll bring our questions and discussion section to an end, but thank you for your participation. And I think I wanted, on behalf of the community of policy professionals, wanted to thank Brendan for such an insightful presentation. It was really good to see how the impact of legislative reform and other operational changes impacts the outcomes and the targets to which we're trying to achieve. and also with that case study in the youth area and looking at whether or not those could be brought forward, I guess, to affect the broader Aboriginal population as well. So we also wanted to thank Oscar for his behind the scenes organisation, and I wanted to thank you, our audience, for your interest and enthusiasm in policy. We'll be back in June, so look out for news of our webinars that will be coming up every month or so throughout the rest of the year. I hope you can join us. Until then, take care.
Thank you very much. That was great, Brendan. Thank you, Louisa, as always.